rule of law, right? The elements of negligence, duty, breach, causation, damages. We know that during the interview, we found out that he was leaving the store through the side entrance. He was carrying that mirror in front of him. And while he was carrying the mirror, he ran into the large pole. He did not see the pole. Why? Because the mirror blocked his view. When he hit the pole, the mirror broke and a piece of glass went into his left eye, causing permanent loss of eyesight, damages. And his claim is the store was negligent in placing a pole so close to the door and wants to sue the store for millions of dollars in damages. Okay, so just reading this, this is a fake fact pattern. This is a fake case. But when I found the Kmart case, I know where your book got these facts from. They just changed the name and the scenario a little bit. So this Kmart case is very close to the Trent Hoffman case. So I want to show you the similarities, and I want to show you why this is a case on point. This could even be a case on all fours. And when I say a case on all fours, it meets every single piece. Okay, and we'll talk about that in a second, but this is definitely a case on point. All right, so we know, let's take a look. You guys did read it yesterday too. So it's a Kmart, it's Kmart Corporation. He's seeking damages for injuries he sustained when he walked into a concrete post. Does that match our facts? You guys are going to help me out on this. Yes or no in the chat. Walking into a concrete post. Do you think that's pretty close to our fact in our case for Trent? Patrice and Ashley? Okay, if you guys are going to step away from your computer, you must private chat me. Just say I'm going to step away for 5 minutes. That way I know you're away and I won't call on you. Okay, so if you're going to step away, please let me know. All right, so he walked into a concrete post. That is the Kmart case. It looks like over here in our case, Trent Hoffman ran into a large pole. So that fact is pretty much on point. Located just outside a customer entrance. Okay, where was this pole? Just outside the door. Those two facts are pretty on point. So far, this is a pretty good case to use for our plaintiff, okay? Another thing, it was a Kmart store. It was a Better Homes or Garden store. That's pretty much on point. At the time of the injury, the plaintiff was carrying a large mirror. Oh, yep. Carrying the mirror, that is definitely a fact on point, which he had purchased from the defendant. Yep, he bought this mirror from Better Home Store. Following a jury trial and a verdict in favor of the plaintiff, the circuit court entered judgment for defendant, notwithstanding the jury's verdict on the ground that the defendant has no duty to warn the plaintiff of. Eek. No duty to warn the plaintiff. So what they're saying here is Kmart has no duty to warn the plaintiff. When you walk outside, there's going to be a big concrete post. Watch out. The court is saying that they don't have a duty to warn. I don't know if this is going to be the best case for our plaintiff to win, because why? This case has already been settled. We'll see what the results are, but I'm just saying, no duty to warn the plaintiff. So there's no way that our attorney is going to fight this in court and say, Better Home Store had a duty to warn. Well, not according to this case, they didn't. And they have similar facts. So it doesn't sound good for our plaintiff so far. Okay. or otherwise protect him from the risk of colliding with the post. Yeah, I don't need to know what you guys are doing. I just want you guys to tell me you're stepping away from your computer because I don't want to call your name. That's all. Okay? Just let me know you're going to leave. I have someone else who's out for 5 minutes doing something. At least I know so that I'm not calling on anybody's name. That's why I'm asking. Okay. Defendant had no duty to warn plaintiff of or otherwise protect him from the risk of colliding with the post. Okay. Well, same thing in our case. I don't think that Trent Hoffman is going to win on a duty to warn. Doesn't sound like it. The appellate court, let's see the appellate court's decision. The appellate court, with one justice dissenting, affirmed that decision. The appellate court agrees. No duty to warn. The judgment and held that defendant owed no duty to plaintiff under the circumstances of this case because defendant could not reasonably have been expected to foresee that plaintiff, while carrying the mirror, would fail to see or remember the post, which was an obvious condition. So they're saying that that post outside the door is obvious on defendant's premises and which plaintiff had previously encountered. Okay. I think the only difference is this person, oh no, this person's using an entrance too. So basically their complaint is this. I mean, the reasoning is this of the court. Here is the plaintiffs, okay? And they've already walked into the store. Let's say the door's over here. The plaintiffs have already walked into the door, into the entrance, knowing when they first walked in, they've seen these big yellow things out here. It's kind of like when you walk into Target. What does Target have? Those big red balls. Everybody knows they're there already because every time you walk into Target, you've got to go around them, or I always see kids jumping on them and all of that. It's another hazard, but anyhow. So they're there and everybody knows they're there. So the point of the court is this. Why did the store have to warn these two plaintiffs if when they walked in, they saw those posts? So are they supposed to have someone at the door saying, be careful when you walk outside, there's 2 yellow posts. Be careful when you go outside, there's 2 yellow posts. No, they already knew they were there. So what the court is saying is that Better Home Store and Kmart did not have a duty to warn about these posts. Okay. And since in this case, they didn't have a duty to warn, and the lower court said no go, and so did the appellate court. They said no go. They said Kmart does not have to warn. And they're going to say Better Home Store does not have to warn. So if you see what I'm doing here, I'm actually comparing a case on point, and I'm comparing the case and seeing how the facts match very closely here. The facts match very closely here, and it just gives us an idea of what our attorney's not going to argue. This is not the great case to take into the, to the courtroom, because it looks like the appellate court decided against our plaintiff, and it looks like the lower court did too. Okay, that's not the final judgment, but that is what happened at the beginning. So let's keep going to see what the final judgment was. Okay, so at this point, Trent Hoffman does not have a very good case based on this case. Okay, all right. Plaintiff's appeals to this court pursuant to our rule, we hold that the defendant's duty to exercise reasonable care extended to the risk that one of its customers would collide with the post while leaving the store carrying a large, bulky item. Accordingly, we reverse and remand. Okay. So it changed up a little bit. What is it changing up? We hold the defendant, who's the defendant, Kmart, in our case, it's Better Home Store, that they had the duty to exercise reasonable care and extended to the risk that one of its customers would collide with the post. Okay, so what they're saying here is no, nobody has to stay at the door and remind them, but they should have done something a little bit better, especially when a customer is carrying a big mirror in front of their face walking out the door. Okay, so they reverse and remand the decision. Okay, who reversed and remanded the decision? The Supreme Court. Okay, the lower court held their decision. The appellate court held their decision, but now the Supreme Court has reversed and remanded. What that means is they're reversing the decision and they're remanding it back to the lower courts to relook at the case, relook at the rule of law, look at our explanation, and come up with a better verdict. That's what's happening here, okay? All right. So defendant operates a department store. I don't want to do that. I think this is great, everybody. This is exactly the facts we need to prove that this is a case on point. Those are the exact facts we need. Also, this tells me this is the case that your book used to create this fact pattern because they're so close. The facts are so close. Okay? All right, so let's see. Same thing here on October 11th. Same thing. He walks in the store, he buys a mirror, he walks out. Let's go to the absolute reasoning of the Supreme Court to find out, should we use this case for our client or should we not? As we were reading at the beginning, we're like, this is not the best case. But then as we get to the Supreme Court's actual decision, it may be a good case for us. So let's see. In sum, we hold that defendant's duty of reasonable care encompassed the risk that one of its customers, while carrying a large, bulky item, would collide with the post upon exiting through the customer door. The jury instructions, which are not challenged by either party, adequately inform the jury of defendant's duty of reasonable care. Who's the defendant? Not our client. There was ample evidence presented at trial to support a finding that a defendant breached its duty and the breach proximately caused the plaintiff's injury. Right here. The final verdict from the Supreme Court, which can't be overturned, by the way, but can go down to the lower courts, come up with this decision. There was further ample evidence of plaintiff's own negligence contributing to his injury. Okay, so we know the defendant breached. According to the Supreme Court, this is a breach of their duty to warn. Reasonable care, right? But we also know this, everyone, our plaintiff is not going to be innocent in this case. Why? Because they're saying here that plaintiff contributed to his own injury. That is absolutely true. We know that our client, Hoffman, decided to carry that mirror out and block his view. You're contributing to your injury at this point. Yes, we know that the store is a little bit, they are negligent, but you contributed to it. And whenever we have a plaintiff, our client, who contributes to the injury, the damages are going to keep going lower and lower and lower, because if a plaintiff contributes to their injury, it's looked at a 50-50 basis. The store is 50% negligent, and who else is 50% negligent? Our client. So if we're looking for $50,000 for damages, our client's probably going to get 25,000 of them because he was contributing to his own injury. Okay, so it looks like that's where this case is going. So we know now, when we write up our legal memo, we can write up, the store was absolutely negligent, right? They breached their duty, and the breach was a proximate cause of our client's injuries. But our client was also contributing to their injuries, thus, the awards are going to be lower, right? So that's how it's going to come out. So if we took that Hoffman case to court and the attorney goes to court with it, we know how it's going to come out already. We don't know the exact damages because everybody has different amounts owed, but we know how it's going, what the verdict's going to be. Okay. So we therefore see no reason to disturb the jury's verdict. The judgments of the circuit court, which is the lower court, and the appellate court are reversed. And this cause is remanded to the Circuit Court of Champaign County with directions to enter judgment for plaintiff in the amount of $68,000. The Supreme Court said, no, no, no. The store was absolutely negligent here. So the Supreme Court told the